now, the National Council of Provinces has voted for the Expropriation Bill. The bill was supported by 7 provinces, with the Western Cape opting against it. It passed into law. If passed into law, I should say, it will allow zero compensation for land expropriation for public and state usage. The constitutionality of the bill has been questioned by political parties such as the DA and the FF+. Joining us is the director and head of the land reform practice at Werksmans Attorneys, and that's Bulelwa Mabasa. Bulelwa, good afternoon. Thanks very much for your time, even though the Northwest, I understand, hasn't really voted. I mean, the majority of the provinces have voted, which then takes this bill another step further in the process of its piloting.
Thank you for having me, Vuyo. It's lovely to be on your program. I think it's important to contextualize this bill in the context of the fact that currently South Africa has been dogged with a 1975 act called the Expropriation Act, which is legislation that was introduced pre-democracy. As I said, in 1975, it did not make provision for just administrative action, and it is in conflict with our current constitution. So, as you will recall, Vuyo, previously, the ANC stance has always been that there's no expropriation that's been on the table. But we saw in 2018, in December 2018, the ANC National Conference making a somewhat of a bit of a change in its policy, introducing expropriation in certain circumstances. And following that December, in February, the EFF led the charge in Parliament, making a proposal to have expropriation without compensation as part and parcel of our law. And this bill has been through so many iterations, all the way from 2019 until we see it where it is today. So it's going to be interesting to see whether or not ultimately there will be a pass of this bill in terms of both constitutionality and in terms of process. Because as you will know, Vuyo, many political parties have different framings in terms of how and when expropriation should happen.
For the layperson, how exactly, or what specific parts of this legislation are deemed to be in conflict with the Constitution?
I think it's difficult to explain it given the short amount of time that we have. But I think the best way to say it is the following. Already our Constitution contemplates that there will be circumstances in which expropriation can happen at less than market value. What has historically happened against the Constitution is that whenever expropriations were happening, government tended to follow only market-related compensation. However, the Constitution itself says that that expropriation should happen, taking into account a couple of factors. One of those being, yes, market value is only one of them, but there are other things that government should take into account, or the state should take account. And one of those is the current value of the property, how the property was dispossessed, whether or not there have been any capital improvements on that piece of land, and so forth. So when I was part of the Presidential Advisory Panel for land reform, the idea that panel, the expert panel, had was that, yes, the Constitution does allow for expropriation to happen at less than market value, but that the Constitution is very clear that it is compensation-based. It does contemplate a payment of monies and sums to the original landowners. So really what this bill seeks to do is to bring it in accordance with the constitutional framework. It allows the state to be able to expropriate at less than market value, and in some circumstances at zero value. Let's give you a practical example. For example, you would have seen that there are many derelict buildings sitting fallow in the city center. Many of those buildings have owners that are not traceable. Some of those buildings have their indebtedness to the states in terms of rates and taxes even goes beyond the value of the buildings themselves. So we've set down as part of the Presidential Expert Advisory Panel to say, what are those circumstances, what are those low-hanging fruits that can make it possible for government to expropriate without compensation? So it seeks that there are those circumstances that can allow it, and for that reason, it would then entail a constitutional amendment because, as I said, the current framing of the Constitution is such that it is compensation-based. So really this is to enable government or the state to be able to acquire property for the public interest, in the public interest, such as land reform, for example, at drastically less than market value, and in some circumstances at zero rand. I must point out to say the question of expropriation is only as an iceberg into solving our wider land reform issue. All that expropriation does, it enables the state to acquire certain land for specific purposes. However, the issues that are facing South Africa today are issues that go well beyond the issue of expropriation with or without compensation. It's issues around the availability of land. It's the issues around land use management. It's issues around having new policies around evictions. It's issues around land redistribution. How can people acquire land? For what purpose and for how long? Those that have land needs. It's also around restitution. How does the state democratize the ownership of land by various groups of people, such as CPAs and trusts? So it's important for us to understand that the over-focus on expropriation without compensation, usually it's a subject that, comes to be, especially during election time, but that it overshadows many other issues that should receive even more attention than the attention that is just placed on expropriation, Vuyo.